session. Please be seated.
For the record, Justice Toone has replaced Justice Smith to hear this last case, which is 23P 1467 KRUMSIEK as the personal representative of the estate of Helen KRUMSIEK versus Collins Electrical Company. Mr. Egan.
Good afternoon. My name is Jack Egan with Daniel Ford, who is serving as special counsel on the appeal. We represent Collins Electric Corporation. The multiple errors evidenced in the record below resulted in an absurd result, which is reflected in the judgment presently before you. Now, I use the word absurd not for rhetorical flourish, because that is the precise word employed by the SJC in multiple cases in which they instruct that in the matter of contract interpretation, an absurd result is never to be tolerated. But here, the plaintiff seeks to recover contract damages in the amount of $3 million, then to void that very same contract and retain the property for which the damages were awarded. That would be a first in the Commonwealth. Further, the plaintiff seeks here, as another example of an absurdity, to recover a per-share value for a single share of common stock in my client, Collins Electric, in an amount of $41,000 per share. Now, I say that's an absurdity because 10 months before, under these very same documents, a single share of Collins Electric stock was valued at slightly over $6,000 a share. So the interpretation that my brother urged successfully below, the court adopted, would result in a 700% increase in the value of a single share under the same stock redemption agreement and 5 amendments in a matter of 10 months, in which, as you can see...
Mr. Egan, you're flying at 30,000 feet. Let's talk about the issues you've raised rather than the absurdity of what the relief is they requested. Let's first address the prior conduct issue that you are prohibited from doing. Why should we reverse the judge on that?
I'm sorry.
The first issue in your brief.
Yes.
About the shareholder's prior conduct interpreting the SRA.
Well, evidentiary, you're talking about the evidentiary issue.
Yes.
The trial judge, in our judgment, conflated the parole evidence rule with the course of conduct rule.
Yes.
And denied our opportunity to give the jury that evidence of course of conduct, which was in the 2 prior redemptions under the stock redemption agreement and the 5 amendments. No so-called special dividend had ever been paid.
Let me ask you this: some of the prior conduct that you wish to get in preceded the 5th Amendment, right?
No,
none of it did.
Well, there were 4 redemptions. 2 of them were under the 5th Amendment. Those are the ones, and that would be Sally's redemption and William A's redemption. Those are the 2 we sought to offer.
Okay. And your offer, you had an offer of proof that showed some sort of proportional,
both written and oral,
proportional payout. Right. Yeah.
So, how did this arise? This absurd judgment. What it did, how it occurred is simply because the trial court denied our motions for directed verdict, in which we stressed that it was the obligation of the trial court to interpret the language of the contract. The SJC, in a case cited in our reply brief on page 8, Whitaker versus Brookline, has specifically said that the submission of the question of contract interpretation to the jury is reversible error. He said that in 1945, and that is the law of the Commonwealth. That's what happened here. I'd like to turn to the contract in question, which I refer to as the SRA, and when I say that, I include the 5 amendments. And the reason I want to turn to that is because it's the touchstone for both the claim of contract damages and it's the predicate for the declaratory judgment rulings. The stock redemption agreement and the 5 amendments set forth a clear plan that the family agreed to in 1963, and the 5th Amendment was in 2000. In each one of the amendments, they reaffirmed the initial stock redemption and its purpose. And it was simply put to allow the 6 siblings who were the children of William P. Collins to continue to own their shares of stock in Collins Electric and benefit from the dividends according to their ownership interest. But when they died, then each of their estates was obligated to sell the shares back to Collins Electric. The next generation, the grandchildren, would have constitute 20 separate individuals. So the way this contract was interpreted improperly by the jury, you have 4 of those grandchildren who seek to retain their shares. Our position is clearly, when you read the 5 amendments and the stock redemption agreement, no grandchildren were to benefit. They had contract damages, and each of the estates of the 6 siblings would receive the contract damages. Now, here, there is a claim for contract damages under 2 sections, or 2 amendments, the 4th Amendment and the 5th Amendment. Let me deal with the 4th Amendment first. The amount that was paid as an introduction by Collins Electric, by my client, was $885,000, paid in 2 checks. Under the 4th Amendment, the claim for damages is that they're entitled to collect $890,000. Let me deal with that simply because I think it's easiest to deal with. The jury was asked the question whether or not there was a breach of the 4th Amendment by my client, Collins Electric. The jury answered no. Still, the judgment awarded damages, even though the liability question was answered.
Damages were awarded on the second issue, the dividend payment.
Yes, that's.
So why are we focused on the?
Because they were awarded under both, Justice Toone.
That's not what the judge said. The judge said that the $2.1 million was on the dividend payment.
The judgment actually says, and my brother presses an entitlement to the claim under the 4th Amendment and the 5th Amendment.
Okay.
So that's
like Justice Meade, I'm trying to get to the sort of heart of what the error is here on the jury's verdict. So I think I understand your argument as to the dividend payment, but I don't know why we're talking about the first piece that the jury returned.
We're talking about the 4th Amendment because they're claiming $890,000 worth of damages under it, even though the jury said no. To move to the 5th Amendment, in the 5th Amendment, they're claiming what I call entitlement to a special dividend. And the special dividend is found under the 5th Amendment, which was executed in February of 2000, under the language captioned dividend in the year of death. Just as an aside, but not an insignificant aside, there's no language in either the SRA or any of the 5 amendments which indicates the captions are to be given any less force than the rest of the language. So dividend in the year of death has 3 paragraphs under it. The bottom one is simply a reaffirmation of the prior agreement. So we're dealing with the first 2. The first 2 deal with separate circumstances. The first paragraph under dividend in the year of death deals with a circumstance when the company employs an estimate of earnings in its per-share valuation. That's the paragraph under which they claim entitlement to a total of $2.1 million. In fact, the company did not use, and it is uncontested, did not use estimated earnings. It used actual earnings. And when you read both paragraphs together, the second paragraph, which my brother does not make any claim under, provides for the scenario when the company uses actual earnings to value a single share of stock. That's what was done in this case, but they claim they should be entitled to recover for a situation when estimated earnings were used, and they claim that because they claim that generates a very significant amount of funds in terms of their damages. If you read, as the trial judge was required to do, the entire contract, he sees, or you see, or the court sees, that the parties had two separate scenarios. And even though it's to your advantage, you can't claim under one scenario when the factual predicate is not there. And this infects not just the damages, but this also infects the declaratory judgment.
Can I, we don't have much time, Mr. Egan, so on the fifth paragraph, which they got the entire net income for the year for the company, you say should have been allocated proportionally for Helen's shares.
That's correct.
But the fifth paragraph doesn't say that.
Respectfully, first, I don't want to lose my argument that the Fifth Amendment,
We're running out of time.
doesn't apply. I'm not going to rehash it. It doesn't apply because estimated earnings were not used. But dividend, the word dividend, the parties agreed. It's not just a matter of defining what dividend means. It's also a matter of the evidence in this case. The personal representative was asked whether or not dividend means a return on your equity, 17%. He answered in the affirmative. Further, just to look at the plan of the family, the dividend doesn't mean 100% return of all of the other siblings' equity. It means you get 100% of your dividend, not 100% of their dividend. So that's the distinction we say the language draws, Justice Meade.
But where does that come from?
That comes from the Fifth Amendment.
But those words aren't in there.
The words are, and I don't have it in front of me now.
I do.
Well, you have an advantage on me. But I have read it many, many times.
Me too, and it's far from clear.
Respectfully, I would say that you get what it means. The 100% refers to your dividend. It doesn't refer to everybody else's dividend.
Well, the representative says the next paragraph, the second paragraph,
Right.
lays it out in a very clear fashion about how proportional things are paid out. And it says, therefore, they knew how to write the agreement, and they chose not to do that. And they say that what brought on the amendments to the SRA was that in the past, when people had died, they're inadequately compensated. So this was an adjustment of that policy. And the remaining shareholders will, although maybe in the short term, be out some income. In the long term, they'll have a greater proportion of shares.
That's when we go back to the absurd result. If that were true when 3 or 2 died in the same year,
right,
there would be no money in the company.
well, they'd say they could take out notes to take care of that. It'll be an adjustment in accounting.
Again, I'm sorry, I didn't hear you.
They say that you can take out notes and pay with interest over time if that.
They say that, but I understand that they say that, but we respectfully disagree with that.
I definitely appreciate that.
Pardon?
I definitely appreciate that you disagree.
All right. let me just say that it's important, very important for the court to bear in mind that the predicate for the declaratory judgment findings is that somehow Collins Electric breached the stock redemption agreement. We respectfully disagree with that most strongly because it cannot be said if there was no money due under the 890 and if the if the paragraph dividend in the year of death only applies when estimated earnings were used and they were not used, then there's no predicate for the statement that Collins Electric violated the stock redemption agreement.
You're out of time, but I have one other question. Perhaps the panel has others too. But relative to that you changed your position in the course of this litigation that you earlier had said the plaintiff was not in breach, there was no wrongdoing by him or Helen, and then and that was the answer to an interrogatory. And then when you opened, you changed that position, and then they asked for a corrective measure, which was denied, and the judge later said he regretted not fixing that. So why? I've read your reply brief, but interrogatories don't mean anything?
No.
Answers interrogatories.
What the interrogatories do is these are contention interrogatories as described by the SJC and AG versus Facebook. And what the SJC says is that we still have our work product privilege and attorney-client privilege. Number one, we denied right from the beginning in our answer that they were in compliance with the stock redemption agreement. The contention interrogatory was put in evidence in front of the jury. Also, the SJC says in AG versus Facebook, which we brought to the court's attention, that in these contention interrogatories, in other words, what is your contention? Work product protects, and you do not have to answer. We asserted in our objections.
No, you still have to answer reasonable contention interrogatories. Certainly, you don't have to provide confidential information, but it's very important so the other party understands your position in the case, so they therefore can sort of make adjustments to their litigation strategy in response to those things. So it is, you can't just say, well, we don't have to actually take those seriously because of work product privilege. They're very serious, and you were very clear that you weren't taking that position until the day of trial.
I think, Justice Toone, in AG versus Facebook, which you may be very familiar with,
no, not so much,
that the SJC said that there are types of work product. There's fax work product, in which there's less of a need or less of an obligation to demonstrate a need for on the other side, and then there's strategy or attorney work product, and that is protected. And the interrogatory.
Yes, you don't have to disclose your legal strategy, but you do have to sort of be candid about the positions you're taking in the case as to whether you're making a contention as to the other side breached the contract. And this may not be that material because the judge allowed you to make the argument even though he later regretted it, but you can't just say because there's work product privilege that contingent interrogatories don't have an impact on the litigation. They clearly do.
I guess we disagree on the SJC's, Justice Kafker's, what he says in Facebook, but it all went before the jury anyway, so.
Okay, thank you, Mr. Egan.
Thank you.
Mr. Perry.
Thank you, Your Honors. May it please the court, my name is Timothy Perry. I represent the plaintiff, James KRUMSIEK, who is the personal representative of the estate of Helen KRUMSIEK. With me is my co-counsel at trial, Dave KRUMSIEK. To address the initial issue, there's really two stock agreements at issue. There's the stock redemption agreement, which controlled 64 shares, which are the voting shares. Those are the shares that Helen KRUMSIEK got as a member of the family originally, and then in the 80s and 90s, there was a series of stock purchase agreements. Those are, I believe, Trial Exhibit 49, Those are the 12 non-voting shares that Helen KRUMSIEK bought, and those are controlled by separate agreements. So I think there's we disagree with my brother, obviously, strenuously, and agree with the trial court that, particularly in his amended findings, those were treated separately.
They weren't treated separately at the trial, though, right? The judge is very clear that he was kind of vexed by the fact that this distinction between non-voting and voting shares really was an issue before the jury. It only came up in post-trial proceedings. Isn't that correct?
That's correct, because there was a reason for that. Number one, during discovery, we didn't get those until very late in the game. The stock purchase agreement, the 12 shares, those had been, and so, but the formulas are the same. So the formula.
Ask what the big problem with your position, as I see it, is you seem to be having your cake and eating it too, with respect to.
I was about to use that phrase.
Oh, I'm sorry, I beat you to it. So you get $2.1 million of the dividend payment, and you also get to keep 64 of the voting shares, which seems very curious to me. And it seems to me like you're now kind of basing that distinction on this distinction in shares, but this wasn't before the jury, right? The jury wasn't making a distinction as to the non-voting and voting shares when it issued that remedy. It issued the remedy for all the shares. So I guess that gets to my question of how can you possibly justify the duplicative recovery you got here?
Okay, and it's because it's not duplicative, and it's handled very well by the court, because it came up as a result of my brother's arguments requesting a determination on these two different stock agreements. So in his motion to alter and amend the findings, counsel pointed out that there were two agreements at issue, and that there was the stock redemption agreement that controlled the 64. That had been determined that that had been violated because the monies had not been offered under the Fifth Amendment. And that stock redemption agreement for the 64 shares under Section 9D allows the shareholder to terminate the agreement. Counsel pointed that out in his motion to alter and amend and said, well, that only handles the 64. And we had terminated the agreement, and we were able to retain the shares. He requested the court look at the stock purchase agreement, which controls those other 12, and counsel argued correctly that there was no termination provision under the stock purchase agreement. And so the shares have to be sold back. Those shares have to be sold back to the company. That was counsel's argument.
That was the 12, you say?
The 12
not the 64.
are required to be sold back. If you look at...
So what happens to the 64?
So the 64, we terminated the agreement by virtue of the jury's verdict that we had not been paid. And under 9D, the court allowed us to terminate the agreement. We retained those shares.
But how do you get $2.1 million for turning in essence, 12 shares, right?
Correct.
You got the bag of 64 that you say, oh, because they asked, we exercised our right to terminate. But you agree with me, though, that you can't terminate and then get a damage award on those 64.
Correct.
Which leads me to the mathematical, I'm going to use the word absurdity, of 12 votes equating to $2.1 million? From where?
Correct. And I would disagree with that term, and I disagreed obviously below when that term was bandied about, because it's a simple formula. And so basically the shareholders, some of them were asked whether they wanted to purchase shares in the 80s and 90s. They had to pay out of their own pockets for those shares, and they were given the right to be compensated for those shares at their death, okay? And that was a simple formula, and it says right in the agreement, the original stock purchase agreement, sorry, the SRA, the original SRA controls how you figure out the price for those shares. Now, this idea that 2.1 million is somehow absurd is inconsistent with all the evidence in this case.
But wait, was the 2.1, you said there's a formula. Was the formula applied to the 64 plus 20 plus 12 together, or was it just applied to the 12? It had to be together because the jury wasn't aware of this distinction during the trial, right? So the 2.1 has to be premised on, in part, the 64 shares that you also claim the right to keep, right? So that's the duplicative piece here.
Well, no, because if you're selling shares back to the company at death, under the Fifth Amendment, you always get that the 100% of the net income. That is perhaps a good recovery for the shareholder.
Let me interrupt on that one.
Sure.
You own one share of a company, and you decide to redeem one company, you get the whole entirety, 100% of the dividends of the profits that year? Is that your argument?
No, because that would never happen in this close corporation. They had all agreed that there were going to be this formula applied to these shares if you were selling them back to the company. The problem for the company was they took an unreasonable position with regard to the stock redemption agreement and played around with it and would not would not pay what was required to be paid. That put them in jeopardy under the stock redemption agreement of the termination, which happened. These other shares were subject to the same formula based upon what the agreement says.
So the estate has the 64 shares, and outside of any restriction in a testamentary instrument, would be free to distribute them any way that doesn't violate the law in general, right?
The 64 shares?
Yes.
No, they have to only distribute them according to the stock redemption agreement. They can't sell them. Is that what your question was?
Well, can they be distributed outside the family is what I'm getting at.
No, they'll continue to be controlled by the stock redemption agreement.
So you can redeem them again when someone else dies?
Correct.
And get the whole?
And get another 2 million?
Correct. Just like everybody else who owns, there are other shareholders who own stocks under the stock purchase agreement. So there's two separate agreements. I really invite the court to look at those because the plain language in those agreements means something. That, under the stock redemption agreement, if you weren't paid, you could retain your rights to hold those shares. We're not saying we own all 76 shares, but as the court determined, when we sell back shares to the company, that has to also be done strictly pursuant to the stock redemption agreement that everybody has agreed to.
But so if there were 65 total shares, 64 of them that you exercised your right to terminate, right? And you just had this one, and you send it back into it. You're saying under this analysis, you get the full $2.1 million.
That's correct, because that's what these parties agreed to, and it perhaps only sounds absurd if you're thinking about trading stock on an open stock market. These shareholders controlled within themselves how they could create.
But you only had one, right? In this example, there's 64 terminated, I hold on, I don't get any more money, but I'm not forced to redeem them and get
Right.
whatever valuation. But I've got this one, and I'm interested in selling just a single one, and I get the windfall of $2.1 million. And then later on, who knows, right? As time progresses. I'm having a difficult time because it's just one share, and it's got to be somehow given consideration as to the whole contract, right?
Correct. And when you look at the whole contract, these parties agreed to do it this way because at the end of your life, you're getting one final payment if the company abides by the agreement. This issue would never have come up if the company had not acted in bad faith. And so it comes up because these parties agreed that you're going to have one final dividend payment. The dividend payment is going to be large, but it's not as large as it's being made to seem. $2.1 million on the shares that were returned to the company, from their perspective, were more than redeemed because they treated the 64 shares, they actually treated all 76 shares as if they had been returned to the company. So those controlling shareholders received $12 million in 2019 and 2020. Those two controlling shareholders, that's what they received, and that's in the evidence, Your Honors. So saying that, these arguments that this was going to bankrupt the company or this was an absurd result is far from the truth. Those shareholders, those shares were very valuable. And as Justice Meade pointed out, they could have paid our clients over 5 years. There was no urgency or detriment to the company.
Let me try one more time.
Sure.
The point of the stock redemption agreement, like you say, is to take Helen shares upon her death and return them to the company in a way so that no other shareholder obtains a majority share. To sort of send them back and pay out Helen's estate, right? That's a one-time transaction. So the only thing that's different here is that the judge said, well, because they didn't pay correctly, then therefore the jury is going to award damages, and also I'm going to let you keep the 64 voting shares. That's the problem, right? And so now you have, it doesn't seem like the purpose of the stock redemption agreement has been carried out because the stock has not been returned to the company. It's still staying with the estate. That seems to be the fundamental problem here. I could see one remedy being, well, just there's no sale, the money stays with the estate for now. Another remedy being the money goes and you get the correct amount of money. But you seem to have won both of these remedies, and that just seems fundamentally wrong.
Okay.
What am I not understanding here?
I think, and I would never say you're not understanding something, but so the distinction is the jury didn't award damages. So the jury was asked the questions it was asked specifically because of how counsel had phrased the position of the company at the time, that the Fourth Amendment had been satisfied because despite the fact that they recognized at the beginning that there was a Fourth Amendment payment and a Fifth Amendment dividends payment due, they combined those so that they could cover the Fourth Amendment. So then the judge asked the jury, and the jury question is, did they timely pay the amount that was required under the Fifth Amendment? They answered no, and they plugged in the numbers, just like all the numbers that had always been plugged in, and they arrived at the $2.1 million. But that wasn't an award of damages. That instructed the findings that Judge Hodge made in his findings of fact and rulings of law. At that point, he found that there had been a material breach, and so on the shares that under the SRA, we were entitled to declare that the contract was terminated. That leaves these 12 shares. And so the 12 shares expressly say, under the stock purchase agreement, expressly say that you use the same formula, at least as far as the Fifth Amendment. And he meticulously goes through how he arrived at the Fourth Amendment payment for the last 12 shares and the Fifth Amendment payment. So the jury's verdict it didn't award damages. It said what was supposed to be paid under the Fifth Amendment.
What is the $2.1 million then? How would you, what label do you give that? If it's not damages.
That's under the Fifth Amendment.
But what is it?
It's a dividend in year of death. And so you get that as a shareholder, no matter if you own one share or 76 shares. And the reason that that's not unfair...
You get that under the stock redemption agreement, even if the stock is not sent back to the company.
No, you don't. So we're not asking for it, and it wasn't granted under the stock redemption agreement. That $2.1 million was granted under the stock purchase agreement, that's Exhibit 49 to the trial, under the stock purchase agreements that she had signed, which say that you get, under those agreements, you also get a Fifth Amendment payout at death. So the two, for purposes of my brother's argument, those two agreements have been melded together, so it seems like we're asking for double recovery. That the judge handles that very well in his findings of fact and the amended findings of fact and rulings of law, where he goes through it. And he treats them separately because the stock purchase agreement and stock redemption agreements are treated separately, were signed separately, and my client, his decedent, paid for those extra shares.
Can I ask you this one more?
Yes.
Mr. Egan says today and in his brief that the jury answered special question number 1 that said that CEC had not breached. They asked if they'd been breached and they responded no. Right.
So question 1A was only about the a redemption under the Fourth Amendment. Okay, so, and the parties only asked for the material breach language under the Fourth Amendment because of how the trial went. And basically, before trial, counsel and the defendants had acknowledged that there were 2 payments that were owed, one under the Fourth Amendment, one under the Fifth Amendment. In fact, they had issued 2 checks. At trial, because of how all the evidence came in, and it was very clear that under the Fourth Amendment, $890,000 was owed, and that's what the jury found. They argued at closing, despite the prior positions that they had taken. They argued at closing that if you added the 2 checks that they had given, that were for the Fourth and the Fifth Amendment, that they got very close to the $890,000. It was $885,000. So they said, so that's why the material breach language is only in that question because, well, is $5,000 a material breach or not?
I understand.
That, as we say in our brief, that left them with kind of pick your poison because that left them with 0 on the Fifth Amendment.
All right, we're going to have to leave it there, Mr. Perry.
Thank you.
Thank you all. I'd like to thank my panel, our court officers, our excellent timekeeper, and our clerk's office, and we will stand in recess.
Thank you, Your Honor.